Hello everyone, and welcome to our lecture recording for chapter 10. Today we're going to continue with the analytical structure for the existence of a simple contract. We've already covered in chapters 8 and 9 the first two elements, agreement and intention to create legally binding relations. And today we're going to continue with the third and last element for the existence of a simple contract, which is consideration. We have four learning objectives for this chapter, and you can find these on page 260. We're going to start with the first objective, which asks us to explain the term consideration and recognize its integral presence in a simple contract. Okay. Now at the top of page 261, it explains that in the case of a formal contract, as opposed to a simple one, okay, formal contracts such as deeds, there's no need for consideration. The contract is valid because of its form. But in the case of all other contracts, which are called simple contracts, we need valuable consideration for the agreement to become a contract. And it continues and says this is the third and final step in determining whether a simple contract exists. So for simple contracts we need to establish that there is a valuable consideration, and consideration is defined also on page 261 and says consideration is the price you pay to buy the other person's promise. Okay, it's the price you pay to buy the other person's promise. For example, I promise to sell you a pen and you promise to give me $10. Now, you bought my promise to give you the pen or to sell you the pen because of this consideration of $10, which is the promise you've made. So it's the consideration and the promise at the same time, your promise. So my promise is to sell you the pen, your promise is to pay me $10, and that promise to pay me $10 is that valuable consideration we need for the contract to exist. But there's also a mirror image to the analysis. So if we look at your promise to give me $10, I buy that promise from you with my consideration, which is my promise to sell you the pen. So my promise is my consideration and your promise is your consideration with which I and you buy the other one's promise. Okay. Now sometimes consideration could also be simply by action, like in a unilateral contract. So I have a pet, Fluffy, and Fluffy is lost, and I put out an award for $10 for someone who can find Fluffy for me. So there's a reward here with $10, and your consideration would be simply to find Fluffy. If you find Fluffy, then that's your consideration, and you bought my promise to pay that $10 by finding Fluffy. That would be your consideration. Alright. So as we said, consideration is the price you pay to buy the other person's promise. Okay. So in the case of Dunlop pneumatic tires, they said an act of forbearance of one party or the promise thereof is a price for which the promise of the other is bought, and the promise thus given for value is enforceable. Now, the promisor is the person undertaking the promise. So if I say I will sell you the pen for $10, I'm the promisor. My promise is to sell the pen for that amount. That would be my promise, and I'm the promisor. You would be the promisee because you are the one receiving my promise. Okay? You will receive my promise. In a bilateral contract, there will be a mirror image again, because I'm going to be a promisor for my promise and you're going to be a promisor for your promise. I'm going to be a promisee for your promise and you're going to be a promisee for my promise. Okay? So if I say I will sell you this pen and I'm the promisor, you are the promisee on this promise, then you will also promise to give me $10 for the pen. So here you are the promisor of this promise, and I will be the promisee of this promise, which is yours when you say that you will pay me $10 for this pen. Okay, so there's a mirror image here. All right. Let's then look at the essential elements for consideration, rather the essential rules for consideration, which can be found in the in brief box on page 262. So you'd see that consideration has 9 rules. Okay, so the first one is that consideration is essential in every simple contract, so you must have consideration. There are exceptions, we'll talk about one of them, promissory estoppel, later on in this chapter. And then second rule, that you should consideration should be present or future but not past, and that's the thing we'll talk about more here in this slide. 3, it must move from the promisee. 4, must have some value. Okay, must be something more than the promise of an existing obligation. 6, must be possible of performance. 7, must be definite. 8, must be legal. And 9, must be reliable, or rather referable to the other party's promise. The last one is that consideration must be referable to the other party's promise. Okay, let's then start with these one at a time. The first one on page 162 says consideration is essential to the validity of every contract. So if A promises to give B $100 and B cannot enforce the contract as there is no act or promise on return, this is known as a gratuitous promise and is unenforceable. Okay, unless it's under seal, which is a formal contract, which is not what we were talking about here. So consideration is an essential element in every simple contract. Okay, then we will talk a little bit about consideration and its types. So the second rule says consideration must not be past, it must be either in the future or should be something present, and that's on page 262 to 263. And this slide here is intended to explain this feature of consideration, and it will be done through 2 types of contracts. Both are of course simple contracts, but we talked about this previously. One of them is the bilateral type of contract. So this is back all the way back in chapter 7. So if you go back to chapter 7, you'll find that there is a taxonomy or a classification of contracts, and the classification is given to you in a very nice summarized form on page 195, again in the in brief box on page 195. So looking at the bilateral contract on the left hand side, you'll find that we have 2 promises. A promise flowing from A to B, that's promise 2, and back again from B to A, which is promise 1. So for example, A promises B to sell a pen, and B promises A to buy the pen for $10. Okay, then we have 2 promises, and the consideration here is said to be future, because we are only exchanging promises. None of this has been done yet. So I am promising something in the future to sell you the pen, and you are promising something in the future to give me $10 for that pen. So this is what we call future consideration, and future consideration rather is good consideration. Okay, so that's what we need in order for us to establish the existence of a contract. Now, on the right hand side, you'll find a different type of contract, which is what we call a unilateral contract. This is the fluffy type of contract, where someone lost a pet and they promise. So B promises A, or the world at large, if you find my fluffy, I will pay you $10. Now A is not going to promise B anything. A is going to go and find fluffy. So knowing that there is this offer and there's this promise out there, they would go and find fluffy, and if they find it, then that act in itself is their consideration, and that consideration is a present consideration. Okay, so if promise first, so I promised anyone who finds fluffy $10, that's my promise. If this comes first, and then act in reliance on the promise, so A acts on reliance on B's promise that they will be giving them $10, then that would be present consideration. My act of finding fluffy then is my present consideration. It's present, not future, because it's now done already, and it's happening at the moment as we speak, because I found fluffy. So the present type of consideration is not necessarily something that you have to do right now, but you have done, and it's standing. So the idea of present is that it's still standing in waiting for the $10 to be paid. Okay. However, if you do the act first, before actually knowing about the promise that you will be given $10, then that would be past consideration. That would be past consideration. So if I go out and find a fluffy, say a pet, and then later on I discover that this pet is actually lost, is missing, and then I see, say, an ad somewhere that says that there's a reward for finding the fluffy, then that would be an act that has been done in the past. So my consideration is past consideration. It was not done based on the promise to give me $10. So it wouldn't be a good consideration, and there would be no contract. So it's important to establish the point that past consideration happens usually in these kind of situations where you have a unilateral contract, and it's about something that happened in the past, i.e. before finding out that there is in fact a reward for finding fluffy and for the $10. Now, there's a point I want to emphasize in relation with, to what's sometimes known as the sandwich situations. Okay, so on page 260 it says, if a promise is given after an act has been performed, this will be considered past consideration and is generally not enforceable. Okay, the key word there is generally. The act must be done in reliance on the promise, and then you drop down and it says the rule that past consideration is no consideration frequently means that a promise apparently made seriously generally cannot be enforced by the promisee if it relates to past acts. Of course, if the promise also relates to the future, then that part of the promise will be enforceable. Okay, and there's a case there with Anderson and Glass. And then a continuation on page 264, it says, however, a past act can be good consideration, that's the point that we want to make, where a subsequent promise to pay a specific amount to the plaintiff can be directly connected to the defendant's original request to the plaintiff to perform some service. The performance of that service and the subsequent promise to make payment become part of the transaction. That's Lampley and Braithwaite, and this is from the UK from 1615. Okay, so Braithwaite killed a man and then sought Lampley's help to obtain a pardon for him from the king, and Lampley had to travel to London in his efforts to obtain a pardon, and as a result incurred expenses. After obtaining a pardon, Braithwaite promised to pay Lampley £100 for his trouble, but didn't honor his promise. And the comment, as you see on the right hand side, says the previous request and the subsequent promise were treated as part of the same transaction. So when the request was made, there was an implied promise to pay something, and the subsequent promise of the amount quantified what would be paid. So the quantification is taken to represent or to be part of the same promise that came before it. This is only sensible when it is considered that business is often conducted this way. Okay, so the key point is that sometimes there's something what we call sandwich situations, because the promise that came from Braithwaite was basically before Lampley helped, but even the quantification that came later would be considered still as a sandwich. So it comes from both sides of what Lampley did, the act of Lampley, and that would mean that it would still qualify as a good consideration. Even though it's a past consideration, it would be a good consideration. So the risk management alert, again, remember that as a general rule, a promise made after a contract has been concluded is not enforceable, this is past, unless it can be shown that the subsequent promise can be linked to the original transaction. It can be linked to the original transaction. Alright then, so that's the discussion on page 662, flowing through to 600 and 200 rather than 64. Alright, so we talked then about these first and second rules of consideration, and we're going to move on now and continue with the third rule. So this is what we just been talking about past consideration, when past consideration could in fact be a good consideration. That's again on page 264. And the third rule then is consideration must move from the promisee. So if I promise you to sell you my pen for $10, your consideration must come from you. So you must promise me, for example, to pay me $10 for the pen. You must promise to pay me $10 for the pen, but that $10 doesn't necessarily have to come to me. So I can tell you, okay, I want to sell you this pen for $10, but I want you to pay that $10 for another person. Okay, I want you to pay that $10 for another person. That's fine, as long as that $10 still flows from you. You are the one, you are the promisee, and you are the one who's going to be paying that $10. It doesn't matter whether you pay it to me or to someone else. So consideration must move from the promisee. Okay. The fourth rule is that consideration must have value, but need not be adequate. So I might be selling you a pen that's a gold-plated pen, or it might even be studded with diamonds, or all of that. So its actual value would be something like maybe $1 million, let's say. Okay, but I'm still happy to sell it to you for $10. Okay, and there's no duress, or you're not forcing me basically to sell it to you at that price. I just want to sell it to you at that price. Okay, then the courts will not interfere and start asking questions about the adequacy of your consideration. If I decide to sell you this $1 million pen for $10, then that's fine. You know, the courts, this is legal and that's fine. The courts will not intervene, and we can agree on that $10 as the price at which I can sell you this pen. So consideration must be of value, but doesn't have to be adequate. $10 is enough. That's of value. Doesn't have to be the exact market value for the pen. Okay. Then we have that consideration must be sufficient. So consideration must be sufficient starts on page 266, together with the fourth rule that consideration must have value. At the bottom of the page you find that the question of sufficiency should be distinguished from the question of adequacy. Sufficient is not the same as adequate. Consideration must be sufficient, but doesn't have to be adequate. Okay. So as long as consideration exists and has some value, the courts will not be concerned about its adequacy. That's what we said in the rule number 4. However, it must be sufficient. What does that mean? It must have some legal value. Okay, or it may be considered insufficient and no consideration at all. Okay, so the issue of what is sufficient or of a value recognized by the law as amounting to good consideration is not always clear-cut. Okay, so particularly where the plaintiff is already under an existing legal duty to the defendant. So a number of situations can be identified which can amount to insufficiency. So that's what we mean by insufficiency, and these are the categories that we talk about under insufficiency. So either repeating an existing duty imposed by the law, or repeating an existing duty owed to the promisor, or perform an existing legal duty for a third party. So the key point is that for the first one, repeating an existing duty imposed by the law, the general rule is that repeating an existing duty is not good consideration because it's not sufficient. Same thing with repeating an existing duty owed to the promisor. Repeating an existing duty owed to the promisor is insufficient consideration, and there is no detriment. Okay. However, if you look at page 168, acts in excess of their duty would be considered good consideration. As far as promising an existing legal duty for a third party, which is on page 269, it says performance of an existing contractual duty for a third party is in fact good consideration, and as well as promises to pay lesser amounts. It says that's on page 170. Part payment of a debt. It says where there is payment of a lesser sum is in discharge of a debt, there is usually not sufficient consideration to support the discharge. Okay, there's usually not enough consideration. Okay. However, if you look at page 271, which is part payment by a third party, it says where there's part payment by a third party, the creditor cannot claim the balance from the debtor. This would be viewed as fraud on the third party because they had been led to believe that their part payment of the debt would extinguish the debt. So if you yourself paying less than the amount you are owed under a debt, that's not in itself sufficient consideration. So you can't come and say to a person who, okay, you owe me $10, okay, you owe me $10, and you come and say, look, I'll pay you only 5, which is less than the amount that is due, and that's enough consideration for us to sort of discharge the whole debt, because I can't pay anymore. I can't pay more than that. Okay, that is not enough. That's not good consideration. That's because that consideration is insufficient. However, if my father, for example, or someone you know, or some relative comes and says to me, look, I'll pay this $5 for this person, and that $5 will be considered as discharging the whole debt, which is more than $5, $10, right? But that's still good consideration because it came from a third party. The debt is between you and me, okay? But a third party intervened and wants to pay for you the amount that's owed, but they will pay less in order for us to discharge. And of course that's good for me because I get the money now, which means that I can go invest it somewhere rather than just have to wait until I get the $10 sometime in the future. So there's also benefit for it in it for me, but the key point is that it's being done by a third party. Okay, if that's the case, then as they say on page 271, that is good consideration and the debt is considered discharged. Okay, same thing in relation to forbearance to sue, which is on page 271. Forbearance to sue can amount to good consideration. It is good consideration even if the promise is to forbear only for a limited period or to dispense with a doubtful but reasonable legal claim. All right. Then there is some discussion of composition or arrangement between a debtor and creditor under the Bankruptcy Act of 1966. This is Commonwealth. Again, it says parts of that act allow a debtor to pay a lesser sum to creditors to annul their bankruptcy and put a new agreement in place. Under Section 73, a proposal must be in the form of either a composition or a scheme of arrangement. Both are formal agreements. Okay. And then there's discussion as well of what is a composition agreement and what role does it play in business. So a composition is an agreement to pay monies owed to creditors. Once the composition has been made, a creditor cannot go behind the agreement and claim the full amount owing to them, as this would amount to a fraud on the other creditors. So similar to what we talked about when there's a debt and is paid by a third party. Okay. We looked at then examples of insufficiency, and that takes us then to the sixth rule on page 272. Consideration must be possible of performance. So if the promise of one of the parties is a physical impossibility, for example to walk from Melbourne to Sydney in a day, no real consideration would be present. Okay. So the key point is that consideration must be possible of performance. Seventh is that consideration must be definite. So again, the consideration must be real and identifiable, okay, and capable of expression in economic terms. The eighth rule is that consideration must be legal, straightforward, and consideration must be referable to the other party's promise. So if consideration is not referable to the other party's promise, then the courts will not be prepared to enforce it, and a case in point is Wigan or Wigan and English and Scottish Law Life Assurance Association. I'll leave that for you to have a look at as well, and we will move on to our third learning objective, which talks about an equitable remedy called promissory estoppel, and starts on page 273. Now in the in brief box on that page it says, what is promissory estoppel? So promissory estoppel would allow a promise to be enforced even though the promisee has not provided consideration for that promise. So we've just said that for simple contracts you must have consideration, which is the third element for the existence of the contract after agreement and intention to create legally binding relations. Now we're saying there's an exception to the rule that you have to have consideration for a simple contract to exist. And that exception is what we call today promissory estoppel. Okay? This is equitable remedy, so it's about fairness. Okay? It has to do with someone promising you to do something, okay, and you haven't provided consideration for that promise, but you relied on it somehow to your detriment. So it would be unfair for the courts to come and say, and for the person themselves to come and say that I haven't promised, you haven't actually paid me consideration, so I don't have to honor my promise. That would be unfair in a situation. Okay. So it says, when is promissory estoppel important? So again, it operates where it would be inequitable or unconscionable for the promisor not to be held to their promise. Again, promissory estoppel may be used as a defense or to initiate a cause of action if the promisee's position has been altered in reliance on the promise. So it could also be used as a cause of action. You can be the movement in that situation. So again, the principle of promissory estoppel may provide relief to an innocent party by preventing a party from going back on their word where they have made some representation about the future in relation to their conduct. Okay, so it's really essentially estoppel about future conduct. Now, the modern doctrine of promissory estoppel was established in 1946 in a case called High Trees, Central London Property Trust and High Trees House Limited. Okay, and I'll leave that for you to read, and as we said during lectorials and the colloquies, what we call lectorials or colloquies, we will have a more detailed look at these cases to establish, to better understand these doctrines, and this case of course is the doctrine of promissory estoppel. Now look at the risk management alert on page 275. It says the fact that no formal contract has been formally concluded does not necessarily mean an innocent party has no remedy. If, in the circumstances, it can be established that it would be unconscionable to allow the other party to go back on their promise or deny the truth of a representation. Like everything else, this is a cause of action, so you'll find that it will have elements. So this is the fourth learning objective for today. It says explain the use of the modern doctrine of promissory estoppel. So it has elements, and the elements are listed on page 275. So in order to establish a case for promissory estoppel, we need to have first that there must be an assumption created in the mind of the plaintiff, i.e. the promisee, by the defendant, who is the promissor. The promise must be certain, although it is not necessary that the rights pre-exist. For example, in Walton's, which is the page again on page 275, there was an implied promise that the transaction would be or had been completed. Okay. The second element, so the first element, there must be an assumption created in the mind of the plaintiff by the defendant. Okay. In the case of Walton, for example, it was about negotiating a lease for a commercial premises, and the idea is that Walton's thought that they will go ahead with this promise that they will build a new building on the premises. So it was in relation to, under the proposal, Meher was to demolish an existing building on the site and erect a new building to be leased by the Waltons. Okay, so Walton Solicitor sent a draft agreement to Meher Solicitor specifying that fitting out of the new building had to be ready for commencement of business by the 15th of January of 1984. On the 7th of November, Meher Solicitor spoke to Walton Solicitor, stating that final agreement would have to be reached in the next few days if rebuilding was to be completed on time. Walton Solicitor then forwarded a fresh set of documents with a number of amendments incorporated into them by Meher and a covering letter stating that while he hadn't received formal instructions from his client, that's the key point, he believed that Walton's approval would be forthcoming and that he would advise Meher the following day if Walton's did not agree to any of the amendments. Some days later, Meher's solicitor have heard nothing from Walton's solicitor, returning documents duly signed by way of exchange. Okay, so the idea is that they thought that they would go ahead and demolish the building because they thought that they have secured this negotiation for leasing the commercial premises. It turned out later on that Walton's reneged basically. They didn't want to go because Walton's had instructed its solicitors to go slow while it reviewed its country retailing strategy. So Meher, in the meantime, in the belief that they had a contract, proceeded to obtain finance for the redevelopment of the site and demolished the existing building. Okay, all right. So this is the kind of assumption that you create in the mind of the plaintiff. Second element is that the defendant must be responsible for the assumption. So they are the ones that created this assumption in your mind. The third element, the assumption must be one of fact or law. The fourth, there must be reliance on the assumption by the plaintiff, like the demolition of the building, as we saw in Meher. And fifth, the plaintiff acted to their detriment. And sixth, it would be unconscionable, okay, if the defendant were allowed to go back on their representation. For example, in Waltons, the fact that Waltons said that they would go ahead and lease the premises. And you would see examples where reliance on estoppel was successful, as well as cases where reliance on estoppel was unsuccessful. Both of these are given on page 276. I'll leave that for you to have a look at. But keep in mind the business tip at the bottom, avoiding the operation of the doctrine of promissory estoppel. It says application of the doctrine is really limited to only a suspension of the promisor's rights, not a termination of them. The promisor can withdraw the promise if reasonable notice is given to that effect to the promisee, and it's possible for a return to the position that the promisee occupied before the suspension of the promisor's rights. Alright, so that's basically what I wanted to talk about in relation to promissory estoppel for today. And that brings us to the end of our lecture recording for chapter 10. Next time we're gonna start on the analysis of validity of contracts. In particular, we're gonna look at the capacity of parties to contract, which is of course chapter 11. And until then, I hope you revise again on the existence of contracts, especially the chapters relating to agreement, intention, and consideration, which is chapters 8, 9, and 10, so that you can understand better the next set of analysis which relates to the validity of contracts. We'll leave it there, and I'll be talking to you again soon. Bye for now.